Today, the first big challenge to the raft of legislation put forward by first Priti Patel, then Suella Braverman, and latterly James Cleverly, has fallen at a first hurdle. It's the first in the puncturing. An academic from Newcastle has said that you can only bash so many holes into a policy before it ceases to have any credibility. But we knew this was coming. This is the point. And more than that, there's precedence with the Legacy Act, which was an attempt to unilaterally make a decision about inquests and investigations into the troubles in Ireland and say, they all stop now, we're going to do it some other way. The British government isn't in a position to make unilateral decisions about things which are governed by international treaties. And this is really where, once again, the stupidity of individuals like Suella Braverman, who is trained in law. She'd specialized in immigration law. She'd helped immigrants find their way through this sort of legislation. You would think that she would know something about the details and the complexity of these laws. And clearly her ideology took over from her training. Law is about memory. And if your memory is so swamped with ideology, it's perhaps not surprising that you do stupid things when you're finally gifted with the opportunity of representing the Home Office, of being the Secretary of State for the Home Office, one of the highest offices in the land. Nevertheless, of course, a poisoned chalice. But so today in Northern Ireland, Justice Michael Humphreys pointed out that the human rights provision of the Illegal Immigration Act contradicts the Windsor Framework and contravenes the European Union Convention on Human Rights. And of course, the ECHR underpins the Windsor Framework and as well the Good Friday Agreements, which is why Suella Braverman's obsession with getting rid of the ECHR and its role in British life is so absurd, because it brings the whole of the Northern Ireland peace agreement tumbling down, and nobody could do that. Partly, no British government could do that, partly because it's underpinned by international agreements. And if you want to change an international agreement, and I'm the first to say that the 1951 Refugee Convention needs to be updated and made fit for the 21st century, but this is not the way to do it. Standing at the dispatch box, insulting Pakistan, insulting Albania, and trying to push through legislation simply on the whim and the say-so of some minister charged with the idiocy of control and ideology, that isn't the way forward. This is why Suella Braverman is not fit for public office again. This is why, frankly, Priti Patel, who invented the Rwanda policy, is not fit for public office again, and this is why James Cleverly will have to eventually resign. And when he resigns, whether now or at the general election when he's defeated, there will be a cheer going up. I know people who were at school with James Cleverly, and he didn't stand out as anything particularly surprising then, and I think he's been promoted beyond his abilities. This whole saga under the judge in Northern Ireland today is the first step towards ridiculing this raft of 3 laws, ending with the Rwanda legislation, ridiculing it and demonstrating its disastrous wording and planning. So the challenge today was brought by the Northern Ireland Human Rights Commission and a 16-year-old asylum seeker living in Northern Ireland. And the law, as it's now defined, the Illegal Immigration Act, stops anyone entering the UK without prior permission from applying for asylum, of course in contradiction of the 1951 Refugee Convention, which says that however you arrive in a country, you can then apply for asylum, and you must then be considered legitimate until or unless that asylum is rejected. The Windsor Framework, the judge argued, established not only trade with the EU, but also confirmed the human rights legislation that we shared, which cannot be undermined by Westminster legislation, and the Good Friday Agreement takes priority over any unilateral plans by twits like Priti Patel, Suella Braverman, or James Cleverly, or indeed Theresa May, who was the first twit in the Home Office to decide that rhetoric alone could discourage people from being treated fairly when it came to visas and asylum. She called it the hostile environment. And that simply, as I see it, was an excuse for civil servants to down their tools and demonstrate a certain laziness, build up this backlog of unprocessed applications. So Northern Ireland indeed has the same had the same judicial interpretation to squash the Legacy Act, which mutes any further inquests into the atrocities, and I'm sure it will have the same judicial interpretation of the Rwanda Act and so on. And when one part of the British Isles and one part of the United Kingdom is so compromised legally, I don't see that any other part of the United Kingdom can uphold that law without questioning its value, because presumably if somebody is not allowed entry into the United Kingdom having come to Dover, all they have to do is use our transport system, go to Northern Ireland, where they must be considered under the law that is now put back and now must be enforced after the ruling by Justice Michael Humphreys. Now, there's a fellow called Dr. Tony McGleenan who has said he's representing the government, and he said that an appeal may be considered. We'll be taking our instructions on the judgment, and the position in terms of any further litigation will become clear. I don't think it become clear very quickly, and certainly not before the end of this Parliament. So I think, I mean, I can't be sure, and the determination of the people in the Home Office, as well as Number 10, to get at least one plane off to Rwanda, knowing that the incoming government is going to ditch the Rwanda deal completely. But that determination may force through something that, strictly speaking, is illegal. And then we will have the very interesting prospect of bringing legal cases against former ministers who pushed these laws through. Now, no, there can't be a case against somebody simply for promoting something which turns out to be illegal, but there can be a case for insisting on something going ahead once a judge has pronounced. I think this is a very interesting legal position. It's a very interesting political position, and I think this goes right against the warning that Sunak gave on Monday, that he would be prepared to ignore rulings from the European Court of Human Rights if the Strasbourg court make me choose between the ECHR and this country's security, I will choose our country's security every single time. That may be so, but the problem in this particular case is that this isn't the Strasbourg court. This is a British court on British soil in Northern Ireland with a British judge making it very clear that this is British justice. Now, if Rishi Sunak wishes to ignore that, he is making a statement that Northern Ireland is not part of Britain, and that, I think, will not go well. It will not go down well with his friends and allies in the in Stormont and indeed in Westminster. The DUP, I suspect, will be up in arms about it, and because the implications are constitutional rather than political. I think this could well spell the end of the Rwanda deal. I have my fingers crossed, of course. But Sunak today was chomping on about ignoring the ECHR if it needs to. He repeated this warning. He was prepared to ignore the rulings from the European Court of Human Rights in order to deport asylum seekers to Rwanda. If the Strasbourg court makes me choose between the ECHR and this country's security, I will choose our country's security every single time. He wanted to present the idea as transformational, and that over the next 5 years this country would be brought under control and into a successful Brexit. But he can't defy national judges, and he certainly can't defy the decisions of Northern Ireland. I think he needs to have a serious chat with the Northern Ireland Minister, Chris Heaton-Harris, who is a man who, at least I know, has a clear head screwed onto his shoulders.